So this week it hit the news that a judge had declared that he didn't like Star Wars, and he did so in the middle of a legal opinion. So let's take a look at that. First, the articles. Here's one from CBR.com. Star Wars judge declares The Last Jedi, Rise of Skywalker are mediocre and schlocky. But I figured, let's actually look at the opinion and see what the judge was talking about, because the ruling was not about The Last Jedi and The Rise of Skywalker and Star Wars. In fact, there's no discussion, there's no party, there's no claim that has anything to do with Star Wars. The judge was using it as an analogy or metaphor to make a different point, and how the judge arrives there and what they're making a point about is actually kind of interesting, and I think will give it some context and some impact. You know how whenever you hear about a class action settlement, you hear that the lawyers got a lot of money and the class members got like $3. This is one of those, but I think you're going to like what the judge has to say. We can perhaps sum up this case as how to lose a class action settlement in 10 ways. The parties crammed into their settlement agreement a bevy of questionable provisions that reeks of collusion at the expense of the class members. Class counsel will receive 7 times more money than the class members. An injunction touted by an expert as worth tens of millions of dollars appears worthless, and the defendant agrees not to challenge the plaintiff's attorney's fees amount. Any reduction in those fees by the court reverts to the defendant, and on and on. While courts should not casually second-guess class settlements brokered by the parties, they should not greenlight them either just because the parties profess that their dubious deal is all right, all right, all right. We reverse the district court's approval of the class settlement because the agreement raises a squadron of red flags billowing in the wind and begging for further review. For many years, ConAgra, then owner of Wesson Oil, labeled the product as 100% natural. In 2011, Robert Brezenio and others sued ConAgra alleging that 100% natural label was misleading because Wesson oil contains ingredients made from genetically modified organisms known as GMOs. 3 years later, plaintiffs sought class certification. Relying on the expert report of Colin B. Weir, they argued that they overpaid for Wesson oil based on the 100% natural label. Unsurprisingly, ConAgra then challenged the admissibility of Weir's report, which would mean admissibility as evidence. According to ConAgra, if the public had cared about the 100% natural claim, then the price of Wesson oil should have declined after ConAgra removed the claim from the product's label. The district court agreed, denying plaintiffs' first class certification request. Still hoping to strike oil, plaintiffs filed an amended motion for class certification. Meanwhile, ConAgra agreed to sell Wesson oil to the J.M. Smucker Company in May of 2017. About 2 months later, ConAgra voluntarily removed the disputed label and stopped marketing Wesson products as natural. In early 2018, the Smucker deal hit an insurmountable regulatory jam. Jam? Really? The Smucker deal hit a jam? The district court assigned Magistrate Judge McCormick to help the parties grease the wheels of justice. The judge's puns here are starting to stack up, right? And they emerged with an agreement in principle to sell November 2018. A month later, ConAgra agreed to sell Wesson to Richardson International. The deal closed in February 2019. The next month, the parties proposed a settlement agreement. ConAgra agreed to provide, in relevant part, 15 cents for each unit of Wesson oils purchased to households submitting valid claim forms, to a maximum of 30 units without proof of purchase and unlimited units with proof of purchase. So if you wanted to get your 15 cents back for your Wesson oil purchase, you had to submit receipts or other proof of purchase if you were claiming more than 30 bottles of Wesson oil. So let's just do the math here. 30 bottles of Wesson oil at 15 cents each would be what, like $4.50? Really? They also agreed to an additional fund of $575,000 to be allocated to New York and Oregon class members submitting valid claim forms as compensation for statutory damages under those states' consumer protection laws, and an additional fund of $10,000 to compensate those in all classes submitting valid proof of purchase receipts for more than 30 purchases at 15 cents for each such purchase above 30, with class counsel paying any non-funded claims above the $10,000 from the attorney's fees awarded. With a class of nearly 15 million consumers, ConAgra claimed that it theoretically exposed itself to $67.5 million in claims if every consumer submitted a claim. Spoiler alert, that never happens, not even close. The settlement, however, did not require ConAgra to identify or provide direct notice to class members. So ConAgra seems to be getting a real good deal here, and I think the judge smells something is off. The settlement agreement also provided injunctive relief should ConAgra have seller's remorse and decide to reacquire the Wesson brand in the future. It agreed not to advertise or market Wesson oil as natural, unless the FDA permits the use of the term to describe oil derived from GMO seeds. The parties thus represented that their settlement could theoretically be worth over $100 million, around $95 million in value to the class, $67.5 in potential payout, $27 million in injunctive relief, along with another $6.85 million for the attorneys. Yet, when the dust settled, ConAgra shelled out less than $8 million, with a mere $1 million of that going to the class. So a $100 million settlement turned out to be $1 million going to the class and nearly $6 million going to the class counsel, the attorney's fees. Expenses devoured another $978,000, about $1 million. Of the 15 million class members, barely more than 0.5% submitted a claim. Because really, for 15 cents a bottle, that's not worth the stamp that I have to put on the thing. Now, I'm not saying they had to put a stamp on it. I'm saying they probably had to just submit a form online or something. But still, even if I'm going to go submit a form online and claim 30 bottles, that's $4.50 in recovery? No one's going to do that. As it says here, 0.5% of them did. 0.5%. 1 out of every 200 class members did. Only one class member opted out of the settlement, our hero, M. Todd Henderson, a law professor at the University of Chicago. He objected to the settlement under Rule 23E, arguing that attorneys hoarded 88% of the class's actual recovery. He asserted that our precedent required the court to treat the settlement as a constructive common fund, i.e., the settlement effectively establishes one common fund to pay out both the class members and their counsel. Henderson also contended that the settlement's clear sailing provision, ConAgra's refusal to challenge the agreed-upon attorney's fees, and a kicker clause, any reduction in fees reverts to ConAgra, not the class members, raised the specter of party collusion, which would be when the plaintiff's attorneys, the class attorneys, they know they're going to get some money out of it. So they settle for a quick settlement so that they can get paid and get out of the case. And who cares about the class members? This happened a little bit in Better Call Saul, when Saul was trying to get the old folks at the old folks' home to agree to a settlement. Remember, he was sort of sweetening up the one little old lady and then sort of playing a game between her and her friends and everything, trying to get her to settle. And then when he had a change of heart, he was trying to get them to convince her. Actually, no, I think he was trying to get them to convince her to settle. And then he decided to try and undo that later. But that was kind of collusion. He wanted the money. So you had a fictionized version of what the judge or objecting party is saying could be happening here. When the claims deadline passed, class members made 97,880 timely claims for $418,919, a shadow of the $67.5 million potential liability that ConAgra touted in seeking approval of the settlement. Even with separately funded pools for New York and Oregon, ConAgra would pay class members less than $1 million. Out of a class of 15 million consumers, fewer than 100,000 would receive a single cent. Henderson argued that the kicker demonstrated ConAgra's willingness to settle for roughly 8 million and that class counsel bargained away absent class members' rights in exchange for much of the settlement. The district court disagreed. The court, relying on the lodestar method, which is where you use other numbers. When we talk about attorney's fees, you use other attorney's fees from the area or similar cases. So it's kind of a method of measuring what is more reasonable. The court, relying on the lodestar method, found class counsel's 7 million approximate distribution reasonable given the lodestar amount of nearly 11.5 million. So it was attorney's fees. They're using the attorney's fees lodestar method. Indeed, the court appeared impressed that defendant was willing to pay anything at all, given the many liability and damage issues this case has had from the beginning. The court also pointed to the amount of hours reasonably spent on the litigation, counsel's efforts in litigating this years-long complex action, the results achieved, and the risks inherent in continued litigation. It also emphasized the substantial nature of the 15-cent per unit award, given that it had restricted relief to only the portion of the premium attributable to consumers' belief that 100% natural meant that the products were GMO-free. It thus concluded that the settlement amount offered provided an immediate and tangible benefit to class members and eliminated the risk that they could receive less than that amount or nothing at all if litigation continued. So the appeals court says that the district court erred by failing to apply Rule 23E2, which we're going to go over in a second, which requires the courts to scrutinize attorneys' fee arrangements. Rule 23E imposes on district courts an independent obligation to ensure that any class settlement is fair, reasonable, and adequate, accounting for the interests of absent class members. We have recognized the risks in allowing counsel to bargain on behalf of the entire class, especially pre-class certification, when counsel may try to strike a quick settlement on behalf of the class. District courts must consider the terms of any proposed attorney's fee awards when determining whether the relief provided for the class is adequate. We have observed that courts should scrutinize pre-class certification settlements because plaintiff's counsel may collude with the defendant to strike a quick settlement without devoting substantial resources to the case. Even after a court has certified a class, class counsel still has the incentive to conspire with the defendant to reduce compensation for class members in exchange for a larger fee. Consider this example. What would any rational defendant, so ConAgra, do if faced with these two settlement options? 1. Establish a $10 million fund for class members and pay $3 million in fees to class counsel for a total payout of $13 million, or 2. Set up a $7 million fund and pay $4 million to class counsel for a total of $11 million. A defendant would choose the second option because it would save $2 million even though it shortchanges class members. Nothing about class certification can make a defendant care more about its opponents than its own bottom line. So basically there's a conflict of interest here. The attorneys get a little extra money. The attorney's fee award is not challenged by the defendant, in this case ConAgra, and the class members get 15 cents. And there's no obligation for ConAgra to identify those class members. What would they do? What would be a reasonable thing for them to do to identify them? Because when you go to the store to buy Wesson oil or your groceries, it's not exactly like there's a list of what you bought attached to your account. Well, wait a second, there is. You've got 1 million of these things. You've got these loyalty cards, and the grocery stores and supermarkets and things, they keep track of what you buy for marketing purposes. So 1, they could be subpoenaed to provide relevant data. ConAgra could have to pay them for their time in providing that data, and then those consumers could be notified. 2, you could put up something in the grocery store, put something on the receipt, put something on the bulletin board. Something. There has to be something more than nothing, than no notice, that could be done to notify class members. By the way, if you bought Wesson oil, you get 15 cents per bottle back. Just go make a claim. I still think the 15 cents per bottle is a little low, but I do agree with the district court judge that really how many people would have made a different buying decision had the label not said 100% natural, or had it said 100% natural, but we do use GMO seeds or something. I'm sure they could find a way to phrase it differently, or they did remove it from the label. But really, what is the measurement of exactly how much that's worth? The appeals court then says the settlement had all the hallmarks of a potentially collusive settlement, giving short shrift to the class. So it has all the hallmarks. I don't know if they're saying it was collusive. They're saying it's potentially collusive, and they're going to bounce it back down to the lower court for hearing about that or restructuring of the settlement. First, plaintiffs' counsel received a disproportionate distribution of the settlement. The lion's share of the money, almost $7 million, will end up in the pockets of attorneys, while the class receives relative scraps, less than $1 million. Second, the parties agreed to a clear sailing arrangement. ConAgra agreed not to challenge the fees for class counsel. A clear sailing provision signals the potential that a defendant agreed to pay class counsel excessive fees in exchange for counsel accepting a lower amount for the class members. Finally, the agreement contains a kicker or reverter clause in which ConAgra, not the class members, receives the remaining funds if the court reduces the agreed upon attorney's fees. We identified this as a warning sign for obvious reasons. If ConAgra is content to pay nearly $7 million to class counsel, but the court finds the full amount unreasonable, there is no plausible reason why the class should not benefit from the spillover of excessive fees. So if the fees are unreasonable as this agreement stands, those fees go back to ConAgra, not to the class members. What? We stress that nothing in this opinion suggests that courts should unnecessarily meddle in class settlements negotiated by the parties, or that courts have a duty to maximize the settlement fund for class members. Far from it. We instead follow the rules of our involvement in the class action process set by Congress. Under these rules, the parties can agree to any fair, reasonable, and adequate settlement amount. Under the settlement, ConAgra agreed to refrain from marketing Wesson oil as 100% natural. That sounds great, except that ConAgra already abandoned that strategy in 2017. So it's not a consideration, it's not a bargained for consideration part of a contract. They already removed that label in 2017, so demanding that they do that as part of the settlement is just an empty thing. It's worthless. 2 years before the parties hammered out their agreement, for reasons it claims were unrelated to this or any other litigation. Even worse, ConAgra's promise not to use the phrase 100% natural on Wesson oil appears meaningless because ConAgra no longer owns Wesson oil. In reality, this promise is about as meaningful and enduring as a proposal in the final rose ceremony on The Bachelor. Simply put, Richardson, the new owner of Wesson Oil, can resume using the 100% natural label at any time it wishes, thereby depriving the class of any value theoretically afforded by the injunction. ConAgra thus essentially agreed not to do something over which it lacks the power to do. That is like George Lucas promising no more mediocre and schlocky Star Wars sequels shortly after selling the franchise to Disney. Such a promise would be illusory, as evident by Disney's production of The Last Jedi and The Rise of Skywalker. And then the judge concludes with a section from Hamilton. Two Virginians and an immigrant walk into a room diametrically opposed, foes. They emerge with a compromise, having opened doors that were previously closed. Bros. No one else was in the room where it happened. No one really knows how the game is played, the art of the trade, how the sausage gets made. We just assume that it happens, but no one else is in the room where it happens. Though that process suffices for political compromise and even most settlements, it does not for class action settlements. Because they impose binding judgments on absent class members, federal courts must approve class action settlements and ensure that they are fair, reasonable, and adequate. Under the newly enacted Rule 23E, federal courts must scrutinize attorneys' fees for potential collusion that shortchanges the class, even in post-class certification settlements. We reverse the district court's approval of the settlement and remand this case for further proceedings consistent with this opinion. And that's how the judge arrived at the conclusion that Star Wars is a good metaphor for an empty promise because Lucas had absolutely no connection with what Disney was going to do with Star Wars. There was no agreement. There was no binding anything preventing anyone's concerns from coming true, that the Disney version of Star Wars would be somehow more empty and less satisfying than the George Lucas versions of Star Wars. I absolutely loved episodes 4, 5, and 6, but then when he made 1, 2, and 3, something started to go a little bit off, and then 7, 8, and 9, I don't even know why I'm wearing this hat. Anyway, let me know what you think in the comments below. Thanks for watching. This channel would not exist without your support on patreon.com/ljfrench, sponsors.com/law, floatplane subscriptions, and YouTube memberships. Special thanks in the month of June to the following supporters: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn Abel, ShadowTycho, Earthbound Star, RDHDragon, and PureMagma. And thank you to the rest of our supporters scrolling on the screen in front of you. I'm Leonard French, your favorite copyright attorney. I love you all. I'll see you in the videos. Have a great week. Bye. So this week there were multiple headlines that a judge has declared that Star Wars: The Last Jedi and Rise of Skywalker. Yeah, I'm gonna just start that over.